there, Justin Stivers, owner of the Probate Law Firm, and doing a second video in this series that I'm doing, talking about things that clients and potential clients and people don't ask me or ask us when they are talking about hiring us, but something I think they should be thinking about. And one of the things I see a lot of is a client will come to us with a will, a last will and testament, and it ends up being a copy. And in Florida, that's not a big deal necessarily, but it does require a little bit more work and could make the probate process a little bit longer. It might require some additional steps. And so sometimes people just don't think about it. They think, hey, I've got the will, this is good enough. It looks like it's notarized, it's signed, it's witnessed, and all of that. But they just assume it's fine. And so without getting too technical, in Florida, we can use a copy of the will, but if we don't have the original, we've got to ask the court to approve the copy. And in order for the court to do that, most likely they're going to require that we find the two witnesses that signed the will. So you can imagine that can be a little bit difficult if the will was signed 15, 20 years ago, or maybe the witnesses were at the bank where the notary was, or at the attorney's office, and the attorney's retired and his staff is no longer available. So it does make it a little bit difficult. That's why we always, when we're doing our wills, we want to put down an address and contact information of the witness. Again, they might have moved if it's 15, 20 years later, but at least we maybe have a starting point, because we're going to have to try to find them. If we can't find the witnesses, we're going to try to find whoever drafted the will. So if it was an attorney, a little bit easier to find. There's databases that we can look up to try to find the attorney if we have his or her name. If it was someone who just created their own will themselves, obviously we can't do that. So, it's not something people think about. People just think, or I find that a lot of people just think, hey, I've got a copy, this should be good enough. And usually it is if it's done right and within the requirements of Florida law. But if you've only got a copy, I would say, bring that up to the attorney when you're speaking with him or her so that they know, because the process might change a little bit. There might be a little bit more work involved, and it might take a little bit longer than originally thought. So, I hope you guys found that useful. If you have any questions or comments, please leave them below, and we'll talk to you soon.